by the party's first name. So please take note as we move forward.
You want complete? Yeah.
Thank you, ladies and gentlemen of the press. We will now take 5 questions from you, member of the press.
Thank you so much. My name is Albert Fania, and I do report for QFN. My question to the chairman is that when the court is established, where do you think will be the right area to be set within? Most of that is that, do you prefer people from the Western world to come and preside over the court, or do you prefer Liberians to take care of the court? Thank you.
Next question. Next question.
My name is Delton Gordon, and I report for Flames TV Africa. Chairman, my question has to do with Mr. Jonathan Masakwe, who was being criticized by some Liberians. They think he has some involvement, pleading for some warlords, and now you're here today endorsing him. What can you say about that, sir?
Thank you. There's a follow-up question. My name is Steven Rawosa from QFN. Can you basically tell us what's the difference between this CSO and that of the other CSO that have been criticizing the appointment of Councillor Jonathan Masakwe?
Two more questions.
Yeah, thank you. I'm Domingo. I write for the People's Newspaper in Online. Mr. Chairman, you disappointed in the government you supported, which you serve as chairman for the Coalition of Democratic Change.
last question.
For over the past 6 years, they were not opportune to establish this war and economic crime code. Are you disappointed?
Last question.
My name is Enoch Zul. I report for Africa Media. Chairman, this issue of the establishment of war and economic crime code has been widely circulated that it was just a mere, signing of documents. You filing suit. Do you think this dream is going to come to reality?
Mr. Chairman.
All right, we'd like to say thank you for the different questions, and we'll attempt to provide some answers consistent with what we know regarding the unravelings about the judicial mechanism that has been put in place to ensure more criminals are held accountable for crimes they've committed during the period of war from 1989 to 2003. The first question seeks to know, according to my brother there, where this hybrid domestic code will be situated. Now, in the first place, this is a code for Liberia, and by the TRC recommendation, and from various international protocols on Liberia regarding holding individuals accountable for the commission of war crimes, that code is going to be situated on Liberian soil. And it's going to also be a mixed domestic code. The mixed domestic code, that traditional justice terminology seeks to establish that there will be the presence of local and international judges that will be vetted by credible institutions. In one category, the government of Liberia working with different stakeholders will set up a vetting process that will recruit qualified judges with the requisite experience and qualification to be members of that court. And that is consistent with what is shown in the TRC final recommendation, which is called the consolidated recommendation of the TRC. So the code is going to be situated here, except under security pronged circumstances, meaning if the prosecution of an individual, again, this is a resident clause in the TRC recommendation that was privileged to read, which is a public document. If the prosecution of a particular individual or group of individuals will have national security undertones or will risk the stability of governance in Liberia, there is a clause shown in the TRC consolidated report that requires that under such circumstances, it is within the jurisdiction of the court to determine which geographic location will provide the best and amicable security infrastructure to try those individuals. For instance, if Mr. X is being indicted by the court and there is document that deals to substantiate this indictment for prosecution by the TRC consolidated report information, if that person's prosecution will present serious national security risk, it will be within the court's jurisdiction to decide whether prosecution will be feasible in the foreign country. They will decide to have that person prosecuted in Ghana, or in the United States, or in The Hague, or in Sierra Leone, or anywhere that will provide a conducive security perimeter that will ensure that the stability of governance in Liberia or the West African region is not jeopardized. So, but the domicile of the code is going to be resident in Liberia, which basis has been laid by the resolution of the legislature and authorized by the presidency, with letters sent to the United Nations Security Council to also be participatory in the process. Now, someone also asked as to whether all the judges were eminent from Liberia. Again, the answer to that question is also resident in the TRC consolidated recommendation. It says that there is a process by which judges will be recruited to work within the confines of the court. That may qualify experienced judges that meet the criteria of integrity or at the court level. Now, the government of Liberia will have the responsibility to recruit judges that meet set international benchmark, that meet set qualification for a credible prosecutorial process. And ECOWAS, also working in consultation with international stakeholders, will also recruit and recommend judges to the court. The United Nations Security Council likewise is also going to be under obligation to support that process by recruiting judges that will also form part of the judicial infrastructure of the court. So this is a three-pronged process that does not just give a selection of judges to Liberia. And I think the reason thinkers of that mechanism put that into motion is to ensure the undisputed credibility of the judicial process, so that those that will be recruited to serve within the confines of the court will be above reproach and will meet the best and necessary legal criteria for their functions and their neutrality to serve in those capacities. So yes, there will be judges from Liberia by the TRC recommendation. There will be judges from the UN Security Council. That does not necessarily mean that there are people seated at the Security Council that will come and be judges. It simply means that that institution will preside over the process of recruiting credible judges, okay, from across the globe that will be chosen from a pool of professionals to provide service at that level. Equally, ECOWAS will also recruit qualified judicial practitioners to serve as judges, and the Liberian government also will recruit individuals within the confines of our domestic judicial experience. So all of these different processes will contribute to the viability and the neutrality of the Special Court of Liberia, which name is going to be already tied by the TRC recommendation, which is also a public document. Then one of my brothers asked the difference between the civil society groupings seated around the table and other institutions that are critical of the appointment of Consular General Massacre. It is not for me to state difference of the functions or the capacities of other institutions. We respect every civil society institution in the country. We want to work with everybody, even those that may be diametrical to the appointment of Consular Massacre. Were contacted. Not all, we contacted some of them, and we informed them out of respect that we were going to be endorsing the appointment of Consular Massacre. We have sought to build a consensus of civil society actors across the country to minimize the possibility of divergent views on this issue, because we believe that the issue of prosecuting for war crimes has met national consensus. Every Liberian citizen who means well, who is sensitive for the suffering of our people during the 14 years war stretch, we come to agree that establishing a court to prosecute those that bear the greatest responsibility for war crimes and crimes against humanity is irreversible. It is an international responsibility. It is a domestic responsibility, and Liberia cannot shy from this responsibility because we are signatories to different international protocols that require our obligation of fulfilling the mandate of prosecution for those that bear the greatest responsibility for war crimes against humanity. So they have their position. We will not be critical of their position. In a democracy, everyone has the right to the free expression of ideas. But we are prepared to defend ours because, first and foremost, Consular Massacre is, and that brings me to the next question, probably the last question. Consular Massacre is a qualified legal practitioner. He meets the experience and the benchmark required to serve in the Office of Executive Director for the Office of War and Economic Crimes. He is not just qualified and experienced, he's also one of the advocates for the establishment of a war crimes court for Liberia. How do I know that? Because I'm the lead advocate on this national debate. When people thought it wasn't feasible or it wasn't a realistic pursuit to seek the prosecution of war criminals, that was when we were pushing the debate. We led series of protests. We were arrested for staging peaceful protests while calling for accountability and the end of impunity in Liberia. We sent to jail countless times. We were humiliated, we were beaten and dehumanized. But we did not submit to the whims and caprices of the detractors who thought we were involved in a vain struggle. During that period in 2006, Councillor Massaquoi was one of those that was with us. We carried caskets in 2006 when the late Kofi Annan, who was the UN Secretary General, visited Liberia. We carried caskets and we petitioned the office of the Secretary General to consider promulgating prosecution for Liberian war victims. In that campaign, in that rally for justice, Massaquoi was one of us. He was there. Massaquoi brought flyers because of the Massaquoi in 2006, 2007, 2008. He was with us. Those days on the pavement of Carey Street, when we were emerging intellectuals, emerging advocates, but that were relentless in advocating for justice and good governance, he was one of those that stood tall in defense of justice, in defense of accountability. So he's not just a counselor at law with the requisite experience to preside over that office, but he also became an advocate for justice. So he's familiar with the struggle and the championing of the call for justice for war victims in this country. So those that will surmise or that will presuppose that Councillor Massaquoi is completely removed or disconnected from the struggle for justice for Liberian war victims, then don't know Councillor Massaquoi. But we know him well. We know his history. He has fundamental and functional understanding of transitional justice. Unlike many lawyers that I know, I don't know of many lawyers that were in the street, that were under the rain, that were under the sun, campaigning for justice, bearing caskets, releasing intellectual documents, advocating for war victims, and calling for justice for Liberian war victims, rape victims, murder victims, etc. So that's one. Two, the argument that Councillor Massaquoi, I should be the one defending him because he's a learned lawyer who is capable of defending himself. But for the sake of responding to your question, the argument that Councillor Massaquoi defended a war law or war criminal in the code of law is, in my view, preposterous and does not amount to any judicial weight or intellectual weight in the corridors of reasoning. Lawyers are under obligation to defend clients no matter what they do. It is his responsibility to defend the rights of a client, any client that requires his legal experience or legal practice or legal intervention. And if that client stands in need of a legal representation in a court of competent jurisdiction. So, considering that it's true, I don't know whether he ever defended a war in the court of law, but let's assume that that argument is true. Then it has to be in fulfillment of his judicial responsibilities. So if you went to court, you didn't go to court supporting a war criminal. You didn't go to court supporting the actions of criminals. You went to court defending the right of self-defense of an individual indicted or that comes under indictment for specific crimes. So are you saying that all lawyers in the Republic who go to court in defense of a client are criminals or are supportive of the actions of the criminals they go to defend? Of course, you wouldn't say that. So why is it not the case in one case, but is presumably the case in another? I think those that are propounding these arguments are doing so either out of a comprehensive understanding of the legal practice, or that they may be involved in selfish political engineering to advance personal interest removed from the national objective. Councillor Masakwe, whether he went to court in defense of a client does not make him a supporter of the actions of that client. Councillor Masakwe, if he ever went to court in defense of a client, was doing so in the performance of his responsibilities as a legal counselor, where the law requires that every Liberian citizen is presumed innocent until proven guilty. Where are they proven guilty in the court of law? And you don't go to court without a lawyer. It is in fulfillment of a constitutional clause. So to expect that Councillor Masakwe would default on his legal obligations is to expect him to be a lawyer of prejudice that will be selective about who to defend, who not to defend. Whether you are indicted for murder, whether you are indicted for killing 100,000 people, does not prevent a lawyer from coming to your defense. And if that were the case, he is in the court to defend your rights, not to defend the actions of murder. He went to court to defend the rights of the client, not defend the criminal actions of a litigant or of a client. So these arguments, in my view, and in the view of the opinion of legal expertise, I'm now a legal practitioner, based on my common understanding of the interpretation of law and logic, these arguments will not suffice and should not be the basis for an experienced lawyer, a man of integrity, and an advocate for justice and human rights to be denied a responsibility of performing his portion from performing his duties to the country by serving as the executive director of the Office of War and Economic Crimes Court for Liberia. So we believe in his unblemished integrity. We have a lot of respect for Councillor Masakwe. We think the president made the best decision, but we don't support the president on everything he does. We are a civil society institution that are completely non-political. We don't have a political side. We don't support anybody, or we don't support prejudices. Those that do right, we stand in support of their actions. Those that do wrong, we stand against their action. And so that partisan dynamics where individuals will be driven by support for one side because of their affiliation to that side is not within stand. When President Boakert does something that is reprehensible, we will of course come out in the open and will be critical and take other actions consistent with the rule of law. On this one, we think he needs the commendation of every Liberian citizen for fulfilling commitments made to ensure justice for all victims. Other governments of the past shy from this responsibility for reasons best known to them, and he, amongst other things, decided to commit himself and fulfill that commitment to ensure that the Office of War Economic Crimes Court is established. And on that one, we've already commented in the press release, and we hope that it's going to be accelerated to ensure that justice for all victims will not be denied.
Thank you.
Oh, okay. Well, now, as everything I'm saying is just a repeat of what is shown in the press release. And in the press release, one of the clauses we said that former administrations that had the responsibility by statute to have ensured a mechanism were established to prosecute war victims, and that renege on these responsibilities, they didn't do well for the Liberian people. Because you cannot relent or neglect a constitutional obligation to ensure victims of war receive justice. If someone were to wake up today and take guns, shoot someone, shoot another person,